Welcome to the debate. Today, we are addressing a profound and foundational question of constitutional architecture. Does 14th Amendment constitutional personhood attach inherently at the biological beginning of a human organism? Or is personhood a state-administered legal category distinct from biological life?
Yeah, and this discourse emerges directly from Zachary David Enfield's rigorous treatise, The Perseverance of a Faithful Gavel for the Unborn. We're really going to be examining the deepest roots of American law, science, and moral philosophy to unpack this.
Exactly. And reading through Enfield's work, I found myself entirely convinced by this framework. So I will be arguing that constitutional personhood is an unalienable natural right tethered strictly to the biological beginning of the human organism, and that any legal framework attempting to sever personhood from life is structurally void.
And I will be arguing that legal personhood and biological life have always been, and really must remain, inherently distinct categories. Our constitutional frameworks have to navigate practical thresholds and genuine conflicts of rights, rather than relying on a singular biological event. I'm really looking forward to getting into the weeds on this with you.
Me too. To understand the foundation of my perspective, we have to start with what the treatise calls the empirical anchor. Because this isn't abstract philosophy, right? We are talking about documentable science here.
Right.
In 2016, researchers at Northwestern University published findings documenting a phenomenon that is observable under a fluorescence microscope at the precise moment of human fertilization. When the sperm penetrates the egg, there is a literal, visible flash of zinc ions. It creates a burst of light that scientists call the zinc spark. And this is a reproducible, documentable, biological threshold. Before that exact microscopic moment, there is no distinct human organism. After that flash of light, there is one. So the beginning of the biologically distinct human organism is empirically anchored. And from there, Enfield points us to the textual anchor of the Constitution itself.
The 14th Amendment.
Exactly. Section 1 of the 14th Amendment protects persons. It commands that no state shall deprive any person of life without due process. And when you look at the documented legislative intent of John Bingham, who was the primary author of that amendment, it is abundantly clear he was constitutionalizing the natural law framework of the Declaration of Independence. That framework treats life as an unalienable endowment. It's inherent. It is not some revocable license handed out by the government. Because of that, any legal theory that tries to separate biological life from legal personhood, what the treatise calls the person-life severance doctrine, is structurally void. It fundamentally replaces the amendment's subject matter, turning an inherent right into a mere state-granted permission slip.
Well, I come at it from a very different way. I fully acknowledge the biology of the zinc spark. I mean, the scientific documentation from Northwestern is clear, it's peer-reviewed, it is reproducible. We are not disagreeing on the biology.
Right.
But science and law operate in fundamentally different domains. Science determines when biological life begins, absolutely. But law determines when legal personhood attaches, and how a society functions based on that attachment. Legal systems historically, and I would argue necessarily, distinguish between biological life and constitutional personhood. Just think about how we treat a corporation in the United States. We grant legal personhood to non-living entities to facilitate societal function, right? Allowing them to enter contracts or be sued. Conversely, look at the medical and legal reality of a brain-dead patient. The body may be kept biologically alive through mechanical ventilation, yet we allow the law to recognize the cessation of their personhood for legal and medical purposes. Positing that the 14th Amendment absolutely requires us to assign full legal personhood at the exact microscopic moment of fertilization, it creates unworkable legal absolutes. The law is not a microscope, it's a pragmatic framework designed for balancing competing rights and navigating the complexities of human society.
I see the distinction you were trying to make between biological reality and legal categories, but I must completely reject the premise that the law can or should separate the two when it comes to living human beings.
Why is that separation so impossible, though?
Because it's structurally dangerous. Let me explain. The assertion that the state can define personhood as a legal construct entirely separate from biological reality, is the exact mechanism used in Dred Scott v. Sanford. In that 1857 decision, the Supreme Court didn't try to argue that African Americans weren't biologically human. They knew they were. Instead, the court severed biological humanity from constitutional personhood in order to legally exclude an entire class of human beings from constitutional protection. The 14th Amendment was ratified specifically to overrule that exact mechanism.
But
To claim today that the state can still define personhood as a legal fiction separate from biological reality is to repeat that identical structural error. Now, you mentioned expanding personhood upward to include legal fictions like corporations.
yes,
That is merely a tool the law uses to serve actual human persons. However, expanding the category upward does not legally authorize compressing the category downward to exclude living, biologically distinct human beings. When you allow the state to define personhood separate from biological life, you evacuate the word person of its natural objective referent. You are left with nothing but the state's current administrative preference, which means human rights are subject to the whims of whoever holds power. And I yield absolutely no ground on the danger of that mechanism.
I'm sorry, but I just don't buy that. Let me tell you why. To claim that legal personhood perfectly maps to biology proves way too much, and it completely ignores how human society must function in reality. Personhood requires practical thresholds. If we legally map constitutional personhood perfectly to the moment of fertilization, to that zinc spark you mentioned, we are legally recognizing every single fertilized egg as a full constitutional person
Yes.
in the uterine wall and are lost. If every fertilized egg is a constitutional person, the legal implications for medical care, for miscarriages, and for investigations into natural biological processes become staggeringly unworkable. The law simply cannot function at that level of microscopic granularity. Practical necessity demands workable markers. The distinction between biological life and legal personhood is not some malicious invention meant to strip people of their rights. Like in the historical example you raised, it is a necessary feature of every legal system that has ever existed to maintain order and to apply the law in a way that humans can actually navigate.
I'm not convinced by that line of reasoning, because the practical difficulty of implementing a principle does not defeat the principle itself.
It does if the system breaks down.
No. If we look at Brown versus Board of Education, the Supreme Court faced massive society-altering practical difficulties in implementing desegregation, but the principle of equal protection stood because it was fundamentally right regardless of how difficult the logistics were. Furthermore, the natural loss of fertilized eggs that you brought up, that's a biological process. It is a tragedy of nature and not state action. The 14th Amendment prohibits the state from authorizing the deliberate deprivation of life. It does not mandate the prevention of natural death.
Even so,
The argument that practical thresholds justify redefining personhood fails entirely because the text of the 14th Amendment takes the person as a given. It commands the protection of that category without ever conferring on the state the authority to limit or redefine it for convenience. A state that decides to define personhood narrowly enough to exclude any class of living human beings simply because it is practically easier has not complied with the 14th Amendment. It has nullified it. There is no room to yield on the definition of a person just because the legal administration is complex.
that's a compelling argument, but have you considered the genuine conflict of rights that exist in this specific context? This is where the pragmatic nature of the law really has to step in. Even if we grant the biological reality of the unborn organism from the moment of the zinc spark, a pregnant woman is an already established, fully recognized constitutional person. She has a recognized liberty interest and a right to bodily autonomy that is protected by the Due Process Clause. If the state compels a woman to sustain a pregnancy against her will, that is a massive infringement on her liberty.
But we aren't talking about.
Let me just finish this thought. We are not dealing with a vacuum here. We have two entities with competing interests. This creates a genuine, undeniable conflict of rights that democratic legislatures and courts must balance.
That is exactly why legal thresholds, such as viability, the point at which the fetus can survive outside the womb, have been utilized in jurisprudence. Viability is a reasonable, medically grounded attempt to accommodate both the 14th Amendment liberty interests of the mother and the developing life of the fetus. It acknowledges the biological development while balancing the established legal rights of the woman.
I must firmly reject the premise that this is a conflict of equal, competing rights. This is where Enfield introduces a crucial concept that clarifies the entire architectural structure of our Constitution. He calls it the meta-right structure.
Okay?
We often hear about life, liberty, and property as if they are three equal items on a flat list, like items on a grocery receipt. They are not. They exist in a strict unidirectional hierarchy. Life is the meta-right. It is the absolute non-negotiable precondition for the exercise of every other right. Think of it like a river. Liberty is downstream of life. You cannot exercise liberty or own property or speak freely if you have been deprived of life.
Therefore, a downstream right, in this case the mother's liberty interest, cannot logically be used to revoke the upstream precondition of the unborn organism's life. If you allow a downstream right to eliminate the very foundation of rights itself, you destroy the structural relationship that makes any right coherent. Furthermore, I have to address your point about viability.
Sure, viability is not a principled legal or moral threshold. It is a technological accident. A non-viable fetus today would have been non-viable at any stage of gestation in the year 1900 because the medical technology, the neonatal intensive care unit, simply did not exist. Constitutional rights cannot possibly be contingent on the technological environment of the rights holder. Viability measures the state of our modern medical equipment. It tells us nothing about the inherent worth, the biology, or the existence of the human organism.
But by entirely dismissing the mother's liberty interest in favor of this strict meta-right hierarchy, you are essentially demanding that the legal system impose a singular, rigid, natural law framework onto a pluralistic, secular society. And this brings us to a severe constitutional problem that goes beyond the 14th Amendment.
How so?
Imposing a natural law framework that dictates legal personhood begins at fertilization, violates the Establishment Clause of the First Amendment. The Establishment Clause prohibits the state from enforcing a specific metaphysical or religious viewpoint into secular law. By anchoring constitutional personhood to a theological concept of natural law, this idea of creator-endowed rights that you alluded to earlier, you are asking the state to establish an essentially religious premise as the supreme law of the land, that overrides the democratic process and violates the neutrality that a secular legal system is supposed to maintain. We rely on legal positivism, the idea that laws are established by human authority and societal consensus, precisely to avoid imposing one religious or metaphysical doctrine over all others.
That is perhaps the most profound misunderstanding of both natural law and the Establishment Clause, and it is entirely dismantled by what Enfield calls the convergence argument. Let's break this down. The biological reality of the zinc spark aligns with a universal witness of 9 entirely distinct civilizational traditions. We are not just talking about theology here.
You're saying it's broader than religion?
Far broader. We are talking about Kantian categorical imperatives, purely secular logical philosophy. We are talking about John Rawls' veil of ignorance, which asks us to design a just society without knowing what position we will occupy in it. We are talking about the African Ubuntu philosophy, which dictates that a person is a person through other persons. And yes, this stands alongside the major tenets of Christianity, Islam, Judaism, Hinduism, Buddhism, and Lakota traditions. This is not the imposition of a sectarian religious viewpoint. It is the convergent moral recognition of human civilization. It is pure reason, without any need for divine revelation, arriving at the exact same conclusion regarding the inherent value of human life.
Okay, but even if I concede that multiple global traditions share a general moral intuition about the value of life, that does not translate to a mandate for secular constitutional law in the United States. Legal positivism ensures neutrality by refusing to enshrine any of these metaphysical traditions, whether they are secular philosophies like Kant or religious doctrines, into the hard definition of legal personhood. Positivism allows the state to remain genuinely neutral. It lets the democratic process, the legislature, determine legal definitions based on the current needs and consensus of the society, rather than locking the society into a rigid philosophical framework.
I understand why legal positivism presents itself as neutral, but it is not neutral. It is in fact a direct violation of the Establishment Clause itself.
That's a huge claim.
Let's apply the Supreme Court's own functional tests from cases like Torcaso v. Watkins and Welsh v. United States. In those cases, the court established that a belief system qualifies as religious if it occupies a place in the believer's life parallel to that filled by the orthodox belief in God. Legal positivism operates precisely as an established secular religion. Think about it. It provides a governing account of ultimate reality. It occupies the place of final, unquestionable authority. It mandates absolute adherence. And, most importantly, it explicitly excludes all competing accounts of ultimate authority, namely the convergent natural law tradition we just discussed. When the state adopts positivism to exclude the convergent conclusion of every other major tradition, it is preferring the one creed that denies what all others affirm. That is unidirectional preference. Natural law, precisely because it is the convergent conclusion of all serious moral and philosophical traditions, is actually the only genuinely non-preferential framework available to the state.
I understand the philosophical weight you are placing on convergence, but the Supreme Court's jurisprudence and the operational day-to-day reality of the American legal system relies on positive law. The claim that legal positivism is an established religion under the Welsh test is an incredibly aggressive reinterpretation of constitutional law. The state simply must have the final authority to define its own legal terms. Otherwise, the entire legal system dissolves into competing philosophical treatises. If the state cannot define who counts as a person for the purposes of its own statutes and laws, then the democratic process is fundamentally undermined. We return to the reality that society requires laws that are enacted, debated, and recognized by the state, not abstract moral realities that exist solely in the realm of philosophy or universal witness. If the people want to change the definition of personhood, they use the democratic machinery to do so.
But the democratic process cannot consume its own foundation. This is what we call the democratic paradox. Democracy itself presupposes a class of persons with rights that exist prior to and independent of the democratic process. Life is the precondition of democracy itself. A democratic process that attempts to vote on whether the meta right of life attaches to a specific class of living human beings has committed a massive category error. It is treating the very precondition of the process as if it were a subject of the process. You cannot subject the unalienable right to life to a democratic vote without destroying the legitimacy of the vote itself. Consider the Northwest Ordinance, an organic law of the United States. It explicitly demands that government incorporate religion, morality, and knowledge. Legal positivism systematically excludes morality and religion from the foundation of law, leaving only procedural knowledge. It leaves us with a system that knows exactly how to operate the machinery of government, but is entirely incapable of evaluating whether the machine itself is just.
But your framework relies on declaring that any law that contradicts your interpretation of natural law is void from the start. While Sir William Blackstone certainly wrote that no human law is of any validity if contrary to natural law, the reality of modern constitutional governance is that we simply do not allow judges to strike down statutes just because they conflict with unwritten natural law. That would be judicial tyranny. We rely on the text of the Constitution, as enacted and interpreted over centuries of jurisprudence. The translation of biological reality into constitutional law requires navigating complex liberty interests, societal consensus, and legal definitions that cannot simply be collapsed into a single microscopic event. It is too simplistic a view for a complex world.
The text of the 14th Amendment is the translation. That is the point. John Bingham explicitly documented his intent to constitutionalize the Declaration's natural law framework into the text itself. The text says person. It does not say person as defined by the current preference of the state legislature. When the positivist framework severs the concept of the person from biological life,
It is not interpreting the 14th Amendment. It is completely replacing the amendment's subject matter. If personhood is totally devoid of biological life, we are left with nothing but the state and its current administrative preferences. The person recognized today can be unrecognized tomorrow by a simple majority vote. That is the abolition of man, exactly as C.S. Lewis warned about. It is the reduction of inherent, unalienable rights to revocable state licenses. The zinc spark documents exactly when the life begins. The 14th Amendment commands its protection.
The severance of personhood from life is a structurally void act, and the text of the Constitution demands we recognize that.
Well, this has been a fascinating exchange. In summary, my position remains that while the biological beginnings of an organism are scientifically clear, the translation of that biology into constitutional jurisprudence cannot be absolute. The law must navigate the genuine, established 14th Amendment liberty interests of the mother, and it must utilize workable legal thresholds, such as viability, to resolve very real conflicts of rights. Equating the microscopic zinc spark directly to absolute constitutional personhood strips the legal system of its necessary pragmatism, and it ignores the fundamentally distinct domains in which science and law must operate for a society to function.
And my summary is this. The person is the life. The zinc spark documents exactly when that distinct human life begins under the microscope. The 14th Amendment, based on its text and history, commands the absolute protection of that person. The meta right to life cannot be subjected to a democratic vote, nor can it be logically overridden by downstream liberty interests without destroying the structural hierarchy of rights itself. The person-life severance doctrine relies on a void legal mechanism that turns an endowed, unalienable right into a mere state-issued permission slip. It effectively establishes legal positivism as an unconstitutional state religion that silences the universal witness of human civilization.
It is clear that we have a fundamental and continued disagreement over whether the 14th Amendment takes personhood as a biological given or as a legal construct. The tension between natural law foundations and positivist legal administration is undeniably one of the deepest divides in jurisprudence, and I appreciate the rigor you brought to the table today.
I appreciate your perspective as well. We have certainly reached the bedrock of constitutional architecture today. The complexities of natural law, the definition of organic law, and the structural hierarchy of rights offer a profound landscape for listeners to explore further in Zachary David Emfield's work. The implications of how a society defines a person reverberates through every single layer of its legal and moral existence. Thank you for joining us on the debate. Welcome to the debate. Today, we're diving into one of the most profound questions at the intersection of science, law, and philosophy. When exactly does a human life legally become a person under the Constitution?
Right, and, well, it sounds like a purely philosophical question, but...
Exactly, but as we will see today, it has immense practical legal implications. Specifically, our discussion will analyze the treatises of Zachary David Enfield, which argue that the biological beginning of human life legally commands constitutional personhood.
And the central question we are exploring is really a foundational one for any legal system. Does the empirical biological beginning of human life automatically trigger constitutional personhood and protection under the 14th Amendment? Or does the state possess the legal authority to separate biological life from constitutional personhood? It's a debate that forces us to look at how we define reality in a courtroom versus how we define it in a laboratory.
And this entire rigorous intellectual exchange emerges directly from our provided source material. We will be deeply analyzing what Enfield terms the person-life severance doctrine, the convergence argument, and the broader philosophy of legal positivism. Now, I represent the position that biological life and constitutional personhood are inherently inseparable, making any state attempt to sever them logically void and structurally unconstitutional.
Well, I represent the position that science and law operate in fundamentally distinct domains, meaning legal personhood is inherently a state-administered category that must balance competing constitutional liberties and, the practical realities of governance.
Let us begin with the foundational premise. And on this, I will not concede any ground to the opposing view because the empirical evidence simply does not allow for it. The anchor of this position is objective empirical science. In 2016, researchers at Northwestern University published some truly groundbreaking findings in scientific reports. They documented a phenomenon that is directly observable under fluorescence microscopy at the exact moment of human fertilization. It is a brilliant flash of zinc ions, commonly referred to as the zinc spark.
Yeah, the imagery on that is striking.
It really is. And this is not a philosophical metaphor. It's not a religious theory. It is the undeniable, reproducible, observable boundary where a distinct human organism begins. Before the spark, there is no distinct human organism. Immediately after it, there is one. We must then connect this undeniable biological reality to the Constitution itself. The 14th Amendment explicitly protects persons. Notice that it doesn't define the term. It doesn't define it because it takes the category of person as a pre-existing given, not as a license created and distributed by the state. John Bingham, the principal author of the 14th Amendment, explicitly documented on the congressional record his intent to constitutionalize the Declaration of Independence's natural law framework. Within that framework, life is the meta-right, the absolute precondition for the exercise of all other rights. Therefore, legal positivism's attempt to sever personhood from biological life is a complete legal fiction. It is a structurally void maneuver that contradicts both empirical science and constitutional intent.
Well, before we go further, let's clarify what legal positivism actually means for our listeners, because it really is the bedrock of modern jurisprudence. Legal positivism is essentially the philosophy that laws are rules made by human beings, and there is no inherent or necessary connection between law and morality. It means the state gets to draw the lines for the purpose of maintaining a functional society. Now, I will readily concede the biological reality of the zinc spark. The science from Northwestern University is reproducible, it is clear, and it is fascinating. But the core of the positivist perspective is that this biological reality is legally irrelevant to constitutional definitions. Science describes what is, law determines what counts for legal purposes. Legal systems have always distinguished biological life from legal personhood. Think about a corporation like Apple or Microsoft. Under the law, they possess legal personhood. They can sue, they can be sued, they hold property, they have constitutional protections. But they do not have a heartbeat. They do not have biological life. This proves that personhood is a dial the state turns, not a biological switch.
But that dial...
Let me just finish this thought.
Conversely, look at brain-dead patients on life support. They have ongoing, measurable biological functions, yet they do not possess personhood rights in the same way a living, conscious individual does. The distinction between biology and legal status is a feature of every functional legal system on Earth. The state must establish practical thresholds, like viability or birth, because the state has to resolve genuine conflicts between competing constitutional rights. In this specific context, the legal framework must balance the biological life of the unborn against the mother's 14th Amendment liberty interest and bodily autonomy. Without state-administered thresholds, the legal system simply cannot function.
But notice what you're doing there. You are attempting to frame this as a conflict between two equal rights, and I reject that conflict framing entirely. Enfield's text outlines what is called the downstream-upstream inversion, and it completely dismantles the idea of balancing these specific interests. You are treating the Constitution like a flat list of rights where everything holds equal weight and can be weighed on a scale. That is a structural fallacy. Life is not merely one right among many. It is the meta-right. It is the absolute foundational precondition for liberty, for property, for the pursuit of happiness. Think of it like a building. Life is the foundation, liberty and property are the house built on top of it. You cannot balance a foundation against the house built on top of it.
Right, but
Now hear me out on that structural point.
A downstream right, like a mother's liberty interest, cannot logically or legally be used to revoke the upstream precondition of another entity's life. If liberty can be invoked to eliminate the very life that makes holding any rights possible, you have destroyed the structural relationship of all rights. The moment you allow a downstream right to annihilate an upstream right, the entire constitutional architecture collapses. I give absolutely zero ground on the idea of balancing here. The meta right of life supersedes a downstream liberty interest every single time without exception.
That assumes the foundation you're talking about is recognized as a complete, fully vested entity under the law the moment it biologically exists. But let's look at the reality of what you're suggesting. You are demanding that the law treat a microscopic, single-celled zygote immediately post-zinc spark with the exact same constitutional weight as a fully realized participating member of society, whose bodily autonomy and liberty are being actively restricted. The state faces a genuine conflict here between two entities. If the law does not balance these downstream rights, if it just defers blindly to biology, it effectively erases the mother's 14th Amendment rights entirely. Governance requires pragmatism, not just rigid structural logic.
The scale or size of the organism doesn't change the structural hierarchy of the rights it possesses. A right is not dependent on the physical volume of the entity holding it. If the biological organism exists, the upstream meta right exists. The mother's liberty rights are not erased. They are simply governed by the same natural limitation that governs all liberty. It cannot be exercised to end another person's life. This isn't rigid logic. It's the only logic that prevents the state from arbitrarily deciding who counts as a person.
But the state must administer these categories because of sheer administrative reality.
Severing biological fact from legal recognition is not just a philosophical preference for legal positivists, it is an absolute practical necessity. If we anchor constitutional personhood to the exact moment of fertilization as marked by the zinc spark, we are dealing with a threshold that is completely unworkable for a human court system. Let's talk about microscopic granularity. A massive percentage of fertilized eggs fail to implant naturally. Medical science tells us this is a routine biological occurrence. If constitutional personhood attaches at the zinc spark, are we to suggest the legal system must account for every natural loss of a fertilized egg as the death of a constitutional person? Must we investigate them? The law simply cannot operate at that level. It must operate on workable, visible, administratable thresholds that a society can actually police and regulate. This is why legal positivism insists that personhood is a category administered by the state, because human institutions require thresholds they can actually manage.
Let me address this practicality argument head on, because practical difficulty never defeats a constitutional principle. Never. When the Supreme Court decided Brown v. Board of Education, Southern states argued that integrating schools was practically and administratively enormously difficult. And they were right about the difficulty. It took decades of massive disruption, federal intervention, and administrative chaos. But the practical difficulty of implementation did not defeat the fundamental principle that segregation was unconstitutional. The Constitution does not bend to administrative convenience. Furthermore, you are completely conflating natural loss with state-authorized deprivation. The 14th Amendment explicitly prohibits the state from depriving persons of life without due process.
It does not mandate that the state cure every natural death or investigate every biological failure to implant, any more than the state is required to cure cancer or investigate every death by old age. The constitutional prohibition is against the state authorizing or executing the deprivation of life. But let us look at what you are actually defending when you defend the person-life severance doctrine. When you sever biological humanity from constitutional personhood, you are employing the exact same legal mechanism used in the Dred Scott decision.
Wait, you are equating the legal administration of personhood to the Dred Scott decision. That is an incredibly severe comparison. Dred Scott was about explicitly excluding a recognized class of living, breathing people from constitutional protection based on race in order to maintain the atrocity of chattel slavery. We are talking about the administrative boundary of when rights begin in a biological process. How do you possibly bridge that gap?
The target class has changed, but the underlying legal mechanism is identical. What was the mechanism in Dred Scott? It was the state claiming the supreme legal authority to look at a biologically human organism, acknowledge its biological humanity, and yet declare it a non-person under the law in order to strip it of constitutional protection. That is the essence of the person-life severance doctrine. It is the arrogant assumption that the state can define personhood to exclude a biologically distinct human. Sir William Blackstone, who was the primary legal reference for the founding generation and the framers of our organic laws, stated this principle perfectly clear. No human law is of any validity if it is contrary to natural law. A state defining personhood to exclude a biologically distinct unborn human is not practical governance. It is constitutional fraud. It is void of initio from the beginning. I yield no ground on this. The state does not grant personhood. It is only obligated to recognize the biological reality of it.
But the moment you invoke natural law and quote Blackstone saying laws must align with some higher moral or creator-endowed authority, you run headfirst into the Establishment Clause of the First Amendment. The American legal system relies on legal positivism precisely because we must remain neutral. We live in a pluralistic society with thousands of different religious and philosophical beliefs. We cannot import theological premises into constitutional interpretation. If we base constitutional personhood on a natural law framework that explicitly claims rights are endowed by a creator, as the Declaration of Independence does, we are violating the separation of church and state. The state must define personhood through enacted positive law to ensure that we are not imposing one specific religious doctrine on everyone else. Neutrality demands positivism. It is the only framework that allows a democratic society to vote on and resolve deeply contested moral issues without establishing a state religion.
The source material executes a complete structural reversal of that exact attack, and it is brilliant. You argue positivism is neutral and natural law is religious. Let's actually look at the Supreme Court's own functional tests for what constitutes a religion, specifically Torcaso versus Watkins and Welsh versus United States. In those cases, the court recognized that the orthodox belief in a deity is not required to constitute a religion under the law. Under the Supreme Court's functional test, a belief system qualifies as a religion if it provides a governing account of ultimate reality and occupies the place of final authority in a person's life. Legal positivism does exactly that. It declares that the state is the ultimate authority, that there is no standard above enacted law that governs human action, and it explicitly excludes all rival frameworks. By the Supreme Court's own definition, legal positivism is an established secular religion. It has its own dogma that rights are state-granted, and it is positivism, not natural law, that violates the Establishment Clause. Enfield's text presents what is called the convergence argument. It is a vital piece of this puzzle. The convergence argument maps 9 completely independent philosophical and religious traditions. We are talking about Christianity, Islam, Judaism, Buddhism, Hinduism, the African Ubuntu philosophy, the Yoruba tradition, the Native American Lakota tradition, and even strictly secular Kantian and Rosian philosophy.
That is quite the list.
Exactly. Let's look at how they converge. Despite having completely different views on theology, cosmology, and the afterlife, all 9 of these traditions independently arrive at the exact same conclusion. They recognize the inherent inviolable worth of human life from its biological beginning. Whether it's the Kantian categorical imperative to treat humanity as an end in itself, or the Ubuntu concept that I am because we are, they all recognize the inherent dignity of the human organism. Therefore, natural law is the only genuinely non-preferential framework. By rejecting what all 9 of these diverse global traditions affirm, and by enforcing the one positivist creed that denies it, positivism violates the Establishment Clause. It enforces maximum preference for its own secular creed, actively marginalizing the universal moral consensus of human civilization.
That is a highly aggressive application of the functional test for religion. But let's unpack the reality of the convergence argument. You are claiming that because diverse traditions value life, state-mandated constitutional personhood at the moment of the zinc spark is the only neutral path. But valuing human life as a philosophical or spiritual ideal is entirely different from legally prosecuting a woman or a doctor for terminating a pregnancy. Even if you argue positivism functions as a framework of ultimate authority, it is the only framework that allows a democratic society to function.
Positivism doesn't claim to know the ultimate moral truth of the universe. It simply claims that the law is what the legislature writes down. That is the essence of democratic self-governance. If natural law is treated as an absolute constitutional ceiling, democracy is entirely paralyzed on any issue that natural law claims to govern.
You are removing the debate from the hands of the voters and placing it in the hands of philosophers interpreting biological sparks. Positivism protects democracy by keeping the power to define legal thresholds in the hands of the people through their elected representatives.
If democracy is paralyzed from stripping biologically distinct humans of their fundamental right to life, then democracy is functioning exactly as the Constitution intended. The entire purpose of a constitutional right is to remove certain fundamental realities from the reach of a democratic majority. You cannot vote away the meta-right. Just as a democratic majority cannot vote to establish a state religion or abolish free speech, they cannot vote to sever constitutional personhood from biological human life. That is not a paralysis of democracy. That is the triumph of constitutional design. John Bingham understood this when he drafted the 14th Amendment. He didn't leave personhood up to a state-by-state democratic vote, precisely because he had just lived through a civil war caused by states democratically classifying biological humans as non-persons.
But the historical context of Bingham and the 14th Amendment was about born individuals, formerly enslaved people, being denied their equal protection. To extrapolate Bingham's intent, which was focused on rectifying the horrors of racial chattel slavery for living, breathing members of the community, and apply it to a microscopic zygote the moment a zinc spark occurs, is a massive leap. The state's interest in regulating its citizenry simply has to account for the physical reality of birth and independent existence. The law has always recognized that birth changes the legal equation. To say the state has zero administrative authority to draw a line between a fertilized egg and a born child is to strip the state of its ability to govern human affairs in any practical sense.
The legal equation does not change based on location or level of development. That brings us right back to the empirical foundation. The zinc spark is the reproducible, observable boundary where a distinct human organism begins. Any line drawn after that, whether it's a heartbeat, viability, or birth, is scientifically arbitrary. And when the state draws arbitrary lines to define who qualifies for the meta right of life, it is engaging in the exact type of state-sponsored tyranny the 14th Amendment was written to permanently abolish. I will not yield on the premise that biological reality commands legal recognition. To summarize my position in light of this rigorous discussion, the empirical reality of the zinc spark provides the undeniable scientific boundary of human life. The documented legislative intent of John Bingham and the 14th Amendment explicitly constitutionalized the Declaration of Independence's natural law framework, rejecting the notion that the state grants personhood. And the universal moral witness of human civilization across 9 independent traditions outlined in the convergence argument leaves absolutely no room for the person-life severance doctrine. Life is the meta right. It is absolute. It is structurally upstream of any downstream liberty interest, and it is entirely outside the bounds of state administration, democratic revocation, or positivist legal fictions.
And to summarize my perspective, while the biological inception of life is indeed scientifically clear and brilliantly marked by phenomena like the zinc spark, the translation of that microscopic biology into constitutional personhood remains a deeply complex legal construct. The law cannot simply adopt biology without interpretation, because science and law serve different societal functions. The legal system relies on state frameworks and legal positivism to balance competing liberties, most notably bodily autonomy, and to ensure practical, workable governance in a pluralistic society. Without the ability to establish administrative thresholds, the state cannot resolve the genuine, agonizing conflicts between competing rights holders. Positivism isn't about denying biology, it is about managing society.
We have illuminated a profound structural and philosophical tension today.
We are looking at the foundational rift between natural law interpretations of the Constitution, which treat life as an unyielding pre-political reality, and the doctrines of legal positivism, which view rights as constructs of state administration. There are clearly areas of deep continued disagreement between us, though we undeniably converge on the objective biological facts established by modern science.
The depth of Zachary David Enfield's source material is extraordinary. Understanding the true structural hierarchy of constitutional rights, the history of our organic laws dating back to the Northwest Ordinance, and the complex, often fraught intersection of biological science and jurisprudence requires rigorous, ongoing examination. The questions we explored today are the very bedrock of how a society defines justice.
We highly suggest to you, the listener, that there is far more to explore in the source material regarding these foundational constitutional questions. The treatises provide an incredibly detailed roadmap of these legal and philosophical arguments. We will leave it to you to form your own conclusion on where the law should draw the line, or if it even has the authority to do so. Thank you for joining us for this exchange of ideas.